Hello, Miss Ratliff. My name is Stephen South, and I am in your Procedural Criminal Law class. This video is going to be about the 4th, 5th, 6th, and 8th Amendment. Now, these amendments mean a lot to me because as a U.S. citizen, I'd like to have my rights in this country and be able to do what I can do with these rights. These amendments also mean a lot to me because as a police officer, we give the people of the United States their rights as citizens. As we know, the 4th Amendment is the unreasonable search and seizures. The 5th Amendment is the right for no person should be held to answer to capital. The 6th Amendment is the right to a speedy trial and a partial trial. Lastly, the 8th Amendment of cruel and unusual punishment. First, the 4th Amendment. The 4th Amendment of the United States prohibits the unreasonable search and seizures. It requires governmental searches and seizures to be conducted only upon issuance of a warrant. It is part of the Bill of Rights and was adopted in the response to the abuse of the written of assistance. The 4th Amendment was introduced to Congress in 1789 by James Madison. Along with the other amendments in the Bill of Rights, Congress submitted the amendment to the states on September 28th of 1789. By December 15th, 1791, the necessary 3/4 of the states had ratified it. On March 1st, 1792, Secretary of State Thomas Jefferson announced the adoption of the amendment. Because of the Bill of Rights did not initially apply to the states and federal criminal investigations were less common in the first century of the nation's history, there is a little significant case law for the 4th Amendment before the 20th century. The amendment was held to apply to the states in Mapp v. Ohio in 1961. Early courts' decisions limited the amendment's scope to a law enforcement officer's physical intrusions onto private property. But with Katz v. United States, the Supreme Court held that its protections, such as the warrant requirement, extend to the privacy of individuals as well as physical location. Law enforcement officers need a warrant for most search and seizures activities, but the court defined a series of expectations for consent searches, motor vehicle searches, evidence in plain view, border searches, and other situations. Secondly, the 5th Amendment. The 5th Amendment protects a person from being compelled to be a witness against himself in a criminal case, which in our world today we know this as double jeopardy. Being tried twice for the same defense in the same court. Pleading the Fifth is a term for invoking the privilege that allows us as a witness to decline the answer to questions where the answers might incriminate him, and generally without having to suffer a penalty for asserting the privilege. A defendant cannot be compelled to become a witness at his own trial. If, however, should he choose to testify, he is not entitled to the privilege, and inferences can be drawn from a refusal to answer a question during cross-examination. The amendment requires that felonies be tried only upon indictment by a grand jury. As said earlier about the double jeopardy clause that is part of the 5th Amendment gives you the right to be tried only once in federal court for the same offense. The amendment also has a due process clause as well as an implied equal protection requirement. Thirdly, the Sixth Amendment. The Sixth Amendment sets forth rights related to criminal prosecutions. This amendment allows you as a citizen to have the right to a speedy trial and or a partial trial. Criminal defendants have the right to a speedy trial. In Shrunk v. United States, the Supreme Court ruled that if the reviewing court finds that a defendant's right to a speedy trial was violated, then the indictment must be dismissed or conviction overturned. The court held that since the delayed trial is state action which violates the defendant's rights, no other remedy would be appropriate. Thus, a reversal or dismissal of a criminal case on speedy trial grounds means that no further prosecution for the alleged offense can take place. In Shepard v. Maxwell in 1966, the Supreme Court ruled that the right to a public trial is not absolute. In cases whereas publicity would serve to undetermine the defendant's rights to due process, limitations can put on public access to the proceedings. The accused may request a closure of their trial, though it must be demonstrated that first, there is a substantial probability that the defendant's rights to a fair trial will be prejudiced by publicity, that closure would prevent, and second, reasonable alternatives to closure cannot adequately protect the defendant's rights to a fair trial. And lastly, the Eighth Amendment prohibits the federal government from cruel and unusual punishment. This amendment means a lot to me because there are people out there that get hurt for no apparent reason at all. They get beat to death whenever they get arrested, or they're doing something wrong and a police officer thinks that he has the pure right to do whatever he wants to the person that he arrests. So as an officer, when I become one, I think that that this amendment alone is one that really sticks in my head, because I won't be that type of person to punish someone cruelly and terribly. I will take my rights as an officer, and I will not exceed those rights that the citizens of the United States have. The Eighth Amendment was adopted as a part of the Bill of Rights in 1791. It is almost identical to the provision in the English Bill of Rights of 1689. The provision was largely inspired by the case in England of Titus Oates, who, after the accession of King James II in 1685, was tried for multiple acts of perjury, which had caused many executions of people whom Oates had wrongfully accused. Oates was sentenced to imprisonment, including an annual ordeal of being taken out for 2 days for pillory, plus 1 day of whipping while tied to a moving cart. I can't read this, I'm sorry. The punishment of Oates involved ordinary penalties collectively imposed in a barbaric, excessive, bizarre manner. The reason why the judges in Oates' perjury case was not allowed to impose the death penalty maybe become such a punishment would have deterred even honest witnesses from testifying in later cases. England's Declaration Against Cruel and Unusual Punishments was approved by Parliament in February of 1689 and was read to King William III and his wife, Queen Mary II, on the following day. In England's The Cruel and Unusual Punishments Clause, a limitation on a discretion of judges and required judges to adhere to precedent. Now, I was reading those different amendments that I had typed up myself. In those, while I was thinking about it, it seems that today a lot of those amendments and our rights are a part of our lives, and they will always be a part of our lives. So thank you very much, Miss Ratliff, and I hope you have a good day. Bye-bye.